Hi, good evening, everyone. Akansha ma'am, we can begin.
Thank you. Thank you, Kritika. Good evening, all of you. I'll just share my screen and begin. Okay, we have a lot of attendees here. Great to see all of you here. Hope you all had a great day, and we are meeting here in this evening to discuss about our topic today, that is the legal implications of an agreement, which leads into restraint of trade and what will be the effect out of it. So, before we begin, let me just introduce myself. I am your faculty and mentor at Livelaw Academy, Akansha Singh, and I will be teaching majorly the civil laws here. So, just like any other civil law, we are starting with the most basic one, Indian Contract Act. And under that, I believe that you all have the basic idea of understanding of what is an agreement. So here under section 27, the title suggests us something. Okay. Now let's try to read only the title of section 27 of the Indian Contract Act. If you read it here, it says agreement in restraint of trade, comma, void. That's it. It only talks about agreement in restraint of trade and the consequence as well, that is that it will be void. Now, if you read the entire provision, will you find something in addition to this? It says every agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind is to that extent void. Now we see here that after we read the entire provision, even though the title only named trade, there are multiple other things like profession, business. So we need to understand these terms. Do you remember that case law from your TOTS class of Gloucester Grammar School? 1410 is the time when this particular person decides to make a competitive school in front of the school where he was working. So he was working as a headmaster in the Gloucester Grammar School, and he establishes his own school right in front of the building of this old school where he was working. What do you think will be the legal implication? Can this Gloucester Grammar School sue him because he has taken all the students there? Can they sue him and claim that you have taken all our profits also? Now, keeping that in mind, we talk about this case in torts because the contract between the headmaster and the school has ended. But here in Indian Contract Act, we will be talking about agreement which is between the parties by which the party, one of the party or both the parties have decided to restrain themselves or one person from exercising a lawful profession, trade, or business. Now, what is business, trade, profession? Have you ever heard of these terms in any other subject that you have read? Do we have any right wherein we can claim that I have this right, and not just a right, it's a fundamental right by which I can claim and say that I can perform, I can do my business, I can do the trade of my interest? Do we have any such thing anywhere? So if you have read, we have Indian Constitution, which under Article 19 provides a certain set of freedoms. Now, one such freedom, as you see here on the screen, is to practice any profession or trade or any occupation or business. Now, these terms have been used there as well. Let's try to understand what is profession. After you qualify, after you gain some degree, education, training, you can qualify and say that I am a professional from this field. So, an example can be lawyer, doctor, etc. Then we talk about trade. Trade can be compared as a smaller scale wherein a person is working to seek benefit, profits, and at the same time, this more requires more of a physical skill or craftsmanship. Like, for example, we can talk about a carpenter or a mechanic. And business, contrary to this, is something where economic activities like production happens. So, all these can overlap as well. And that is not something that I am telling you. That has been held by the Supreme Court in one of the judgments as well. So let's try to understand this from this judgment. So my pedagogy in this class is going to be that I'll be using this PPT that you see here. I'll be using my pen to scribble on this PPT. And in addition to that, I have certain judgments here that I'll be referring. So we have paucity of time, so I can't read the entire judgment here. But what we'll do here is we will read the highlighted portion from the judgment for which we are actually referring the judgment. Okay. So when we read this judgment, I've mentioned the name of the case law as well. Yeah, this is the name of the case law, Sudan Singh, etc. versus New Delhi Municipal Committee. In this case, the court took the effort and tried to define certain terms like profession, business, and trade. It says, profession means an occupation carried on by a person by virtue of his personal and specialized qualification. As I said, if you claim that you're a lawyer, you hold a law degree. The word occupation has a wider meaning, and occupation, if you see, doesn't come under section 27. If you are preparing for judiciary, you can expect the MCQ question on these aspects, that they will ask you which is the term which is not mentioned under section 27 of the Indian Contract Act. So you have to remember, even though occupation is mentioned under Article 19, it is not mentioned under the Indian Contract Act. Trade in its wider sense includes any bargain sale, any occupation or business carried on for subsistence or profit, or an act of buying and selling of goods or services. It may include business carried on with the view, as I told you, with the view whether manual or mercantile. So a mechanic, a carpenter can be classified under this category of trade. And then business is a very wide term, which would include anything which occupies the time, attention, and labor of a person. Now, the next paragraph is even more important. If you refer to this part, it says here, the object of using 4 analogous and overlapping words in 19(1)(g) is to make the guaranteed right as comprehensive as possible, to include all avenues and modes through which a man earns his livelihood. See, the idea behind Article 19(1)(g) is to promote a person, to remove idleness from a society, to promote a person to follow their passion, to follow the profession or the expertise that they hold. And likewise, Section 27 of the Indian Contract Act again tries to take us back there only. This also suggests us the same thing. If you are entering into a contract by which you suppress a person from professing his trade, that will be wrong and that will not be a valid contract. So likewise, all these terms that have been used here is only and only to promote a person to follow whatever skills they have, and accordingly no agreement made to restrain such skills or performance of such skills will be considered as valid. So it's very important for us to understand the meaning of these 4 terms before we move ahead. I hope everybody is clear so far. If you have any doubts, you can leave it in the chat box. So far, what we have covered is that I started with Section 27 of the Indian Contract Act. I referred only and only to the title first, just to highlight for your MCQ basis questions that the title only speaks of trade, while the provision speaks of different categories such as profession, trade, and business. And we also try to understand the meaning of this. Then I also introduce you to Article 19, Clause 1(g), which substantiates and which says that this is your fundamental right. If you remember, Article 19 falls in Part 3 of the Indian Constitution. And that is how this is a fundamental right, protecting you to profess, practice the trade profession of your likeness. Now, we have to understand Section 27 from the history of it. As I told you, 1410 Gloucester Grammar School happened. 1872, we introduced Indian Contract Act. What do you think was trade back in 1872? Do you think it was related to IT services, related to intellectual property services? Absolutely not. It was very restrictive. We started our agreement, we started our contract on the basis of barter system. If my city or if my geographical area has good production of rice, I would produce rice and I would take it and give it to you, for because you have wheat to substitute or to barter it with. We started with this basic rule. And then in 1872, the major prominent areas were firstly manufacturing and secondly sale of goods and services. Services also categorically very narrow. So 1872, we could only and only think of this much of Section 27 of Indian Contract Act, that any agreement which is restraining a person from professing his profession, trade, business will be to that extent void. And if you see, there is one exception also attached to it. So this exception here is about goodwill, saving of agreement not to carry on business of which goodwill is sold. So this is an exception wherein you can put a restraint on a person who has sold the goodwill to you. Okay, so we will come to this exception. But the idea here is that when we started in 1872, we had only one exception to Section 27. And that is the reason why I've picked this topic for this demo lecture. Because this is not the only exception. There are various exceptions very beautifully carved out by the Indian judiciary. Law Commission of India in 1959, 6 decades back, they recommended something on the basis of English law. Now, what was this recommendation? They suggested that we have to pick the same principle that is present in the English law. Now, let's try to understand what is there in this English law. English law says that you can put a restraint on trade provided that the restraint is reasonable. And this is what the Law Commission recommended. But so far, till 2024, you do not see this change, legislative change happening in the Indian Contract Act. But the judiciary has come to rescue, and the judiciary has picked this up and taken it further. And we have multiple other exceptions in addition to this exception 1. And that is only and only because we have moved from the traditional system of contract or the traditional system of trade. Now, in the present scenario, if you see 2024, India is the platform where so many big companies are investing. So can we keep something of this sort in mind and accordingly say that, okay, every agreement which restrains trade will be void? Now, if this sounds confusing, let me give you an example. Okay. A enters into a contract with B. Now, A is an employee and B is an employer. The employer, let's say, is KFC. And you don't have to feel hungry listening to KFC. We have time. It's only 7:15, right? So when you hear KFC, you think of their recipes, right? When I want to eat KFC, I know that no other thing can substitute KFC. So that is only and only because of the recipes that they have. And those recipes are called as trade secrets. Let me fix the screen. Yeah. So these trade secrets have now come in the knowledge of the employee as well. And the employee leaves your employment, okay, and goes on to a competitive brand C and gives them this trade secret that KFC holds. Do you think here the employer can stop the employee? Do you think if they had a contract by which the employer puts a clause that you cannot go away and you cannot work with my rival company, will this be part of Section 27? And if this will be part of Section 27, you are stopping this employee perpetually from going to any rival company which provides the same set of food items, going and working there. Will it not be promoting a person to become an idol? Yes. And do we want that? See, Article 19 is not just a fundamental right given to you to profess your trade and business and to make profit for yourself. It is not just a right for one person. It is a right, it is a benefit to the entire society. It is based on public policy. How? You understand, more the trade will happen, more flow of money will happen, and more economy will get flourished in the country. And that is why we do not want such restraints. That is why we have carved out these set of exceptions under section 27. So the entire idea of changing the concept of trade has also changed the way we look at section 27 of Indian Contract Act. So this was our first judgment by which we understood that what can be categorized as business, trade, and profession. We also understood that one exception, even though present in the Indian Contract Act, is not sufficient, and we will need more and more exceptions to read this section or to read this law in the present times. So we have discussed this point, that we have recognized right to trade, business, profession as a fundamental right, and it promotes the interest of an individual as well as the society as a whole. And this is what we are actually looking at. We have to encourage good competition in the society, right? Better prices, better quality of products and goods, and that will not happen if you restrain the other person from performance. Now, in my chronology, I have mentioned 1872, 1874, and 2024. Now, why this? I told you 1872. I hope you remember Indian Contract Act is of 1872. 1874 very categorically, because I will come to this particular case law. And then we will come to 2024. Now, I'll do one thing. When I share these judgments with you, when you refer to these judgments, you will find out that there has been repetition of these judgments time and again. A judgment of 1874 is getting quoted till date because it has given us clarity with respect to one thing. Let me ask you, if you read section 27, what is the nature of this restraint? Every agreement by which one is restrained from exercising a lawful profession, trade, business of any kind is to that extent void. Okay, this is section 27. Now let me introduce you to section 28. I am not teaching you this, only and only for you to compare and find out. So what is section 28? Agreement in restraint of legal proceedings. Every agreement by which a party thereto is restricted absolutely. Right? I am not reading the entire section, but if you see, the nature of restriction is mentioned under section 28, that if the party is restricted absolutely. But when you go back to section 27, no absolute, no partial is mentioned here. And that is why in 1874, in this landmark judgment of Madhub Chandar versus Rajkumar Das, the court had to answer whether restraint under section 27 will be absolute or partial. Let me give you the fact of this case law. There are two parties. Okay. I'll give you a comparison also for you to know what is the difference between these two examples. There are two parties, A and B. Both are sellers or shopkeepers in a particular locality. Shopkeeper 1 and this is shopkeeper 2. Now, shopkeeper 2 realizes that shopkeeper A has been making a lot of profit. He has a lot of clients also. And this has affected him in making his profit. So he promises him that you do one thing, shopkeeper A, you just shut your shop. Okay. Please do not open your shop in this entire locality. You shut your shop and I promise to give you X amount of money. A actually shuts his shop. So the amount of money must be a good amount of money, right? So he shuts his shop and now he claims money from B. And B does not give the money to him. When he goes to court, the court has to see whether whether the court can actually enforce this contract or not. And for this contract to be enforceable, it has to be valid in nature. Can it be void? Can it have any clause which has the effect of being void? Not at all. So the court had to find out whether this will fall under section 27 or not, and whether this is absolute or partial restraint or not. So the court held here that even though you are only asking him to do what? To not open the shop in this particular locality. So is the restraint absolute or partial in nature? It is partial. Now, to come to the conclusion that partial should also be covered under section 27, the court took the help of section 28. Now, if you have read section 27 and 28 with me, do you find any nexus between the two? Not at all. Then why did the court actually refer to section 28? And I'll tell you, it's not me who's saying that. We'll refer to the judgment as well. Okay. So let's see the judgment and try to find out whether the court actually referred to this particular section or not. So this is the case that we have over here. And we will again go to only to the highlighted portion. So these are the fact. It was only to prevent the plaintiff from carrying on business in that particular house, and that he might have carried it out in a house immediately adjoining or any other place. It is obvious that the intention was to restrain him from carrying on business in that locality, making it a partial restriction. Now, why section 28? See, in the following section 28, this has happened. So first I will tell you why section 28, and then we will read the essential part from the judgment. Whenever the judiciary gets into a situation where they have to interpret the law, see, restraint is mentioned, but the nature of restraint is not mentioned. So when the judiciary has to interpret it, it has to take help of different set of aids. Okay. And what are these aids? These are of two categories. Either it can be internal or it can be external. What are internal aids? I have my Indian Contract Act, BEAR Act right now. Okay. If I am, for the understanding of section 27, if I refer to section 28, will this be taking help? Aid means what? Help. Will this be taking help of an internal aid, or is this something external? It is present within the statute, and that is why it will be called as an internal aid. What will be an external aid then, ma'am? What is there beyond this Indian Contract Act, the BEAR Act that you have? So I have my books also, right? If I refer to my book, is that part of the statute? No. So then the book becomes external aid. So whenever the judiciary gets in a situation or in a flux, they have certain aids or help that come into picture. These are internal and external aids. And that is why the court referred to section 28. They said, what are we supposed to do? We are supposed to read the intention of the legislature. And I can read the intention of the legislature by not reading the entire law, by only referring to the provision that is subsequent to section 27. That is the reason why they refer to section 28, and they understand that here restraint under section 28 means only absolutely. But under section 27, where nothing is mentioned, it can mean both partial as well as absolute. That is why we have section 28 being referred in this judgment. Okay. So the legislative authority, when it intends to speak of an absolute restraint, actually mentions the term absolute or absolutely within the provision. So that is how in this particular case of Madhub Chandar versus Rajkumar Das, 1874, we acknowledge that the restraint is absolute and partial, and this cannot be enforced in the eyes of law. Now you remember this space is left. I told you I'll do a comparison. You have to help me with this comparison. Okay. Here again we have A and B. Both sell amazing samosas. So let's say A has a very great samosa shop, a lot of customers who come to this person to enjoy his samosas. And B also opens a samosa shop, but not a lot of people turn up there. What will happen in this situation? Can B try to buy the business of A? And if he buys the business of A, what do I mean by business? Can this be called as goodwill? So Lord Eldon has actually spoken and defined goodwill as a person's tendency to go back to something which he can recall of. I know that I like my phone of a particular brand. When I've broken my phone, I will go back to that particular brand and buy it. I know that I like to eat my pizza from a particular brand. I will only and only open my online platform, Swiggy or Zomato or whatever, and order my food from that platform only. Why is this happening? Because I am associating my taste or my choice of cell phone or devices to that brand. And that brand, whatever name that they have acquired, that is called as goodwill. So if B buys, what happened in this case? Here B told A to shut his shop. But when B tells A that I want to buy your samosa shop, I will now start selling samosas and I will say that we sell A's samosas here. What will happen? Do you think again what happened in Madhub Chandar versus Rajkumar Das will be applicable here? You have to write your answers in the chat box. Okay, write yes or no as to whether the same principle will be applicable here or not. Yes or no. And we will come and discuss this when we come to the exception part. So we have covered 1872, we have covered 1874, and we have also covered 2024 in understanding that the present times has changed. Reading of section 27 has changed in the present context because of the companies investing huge amount of money in the technology, in IP protection, in trade secret. What is a trade secret? Trade secret is a IP protection only. Okay. Now we move ahead and we come to categorization of restraint. See, one categorization I told you that has been given from the Rajkumar case, that is about wherein partial or absolute restraint was discussed. The other categorization is also come by way of judgments. And the categorization is the restraint put on a person when he is in the course of employment versus the restraint put on a person after his course of employment ceases to exist. I'll take a very simple example. There is an employer and employee. While the employee is still working with the employer, this course of service or this transaction is still continuing. And this will fall under the first case. Can the employer put certain restriction on the employee during the employment? The second categorization is the employee has ceased to be an employee. Now also, when he is not related or associated to your company, can you put any restraint on him? Yes or not? Okay. So I hope you have understood the two categorization: restraint during employment and restraint post employment after the employment has ended. Now, what happened in Niranjan Shankar Golikari versus Century Spinning and Manufacturing Company? This one Niranjan Shankar was the employee of this company. Okay. And there are three parties here. So we will say Niranjan, I'll just write it as N. Century Spinning Company, I will write it as C. And Century Spinning Company also had a contract with a German company. So what happened here is that the German company had certain trade secrets that they had shared with this company. And accordingly, it was also present with the employee, that is Niranjan Shankar. Niranjan Shankar was told that we have a term of employment. During this term of employment, you cannot leave, you cannot go without serving the notice period. and work with any other company of similar business. See, understand the example that I gave you, KFC. If you're quitting KFC, you have the trade secret and you start working with a car company, and you've made an online platform for car washing. Do you think KFC would be bothered? Not likely, right? But when we talk about a person quitting the company and reaching to another new employer, which is a rival company, of course it is going to hurt this old employer. And that is what happened here in this particular case. He completed his training, he did not complete his course of employment, and he immediately leaves the company and gets a better package, leaves and joins to a rival company. C goes to the court stating what? Stating this protection of trade secret. You have to read, when you read these judgments, you have to read them in totality to understand. See, facts will vary, facts will change your thinking towards what your conclusion should be. Just because I am saying this happened in Niranjan Shankar does not mean that the fact that you get in your exam, or when your client comes to you, if you are already practicing, does not mean that you have to copy paste the same thing there, right? So you have to see what all facts constituted for C to actually seek an injunction against N. So C was seeking this injunction by telling the court that we have this trade secret that we have to protect, and this person has not even ended the course of employment. So what happened in this case? Let's try to understand from the highlighted portion. I hope you're clear with the facts of the case. Okay. So we have a lot of fact, big paragraph over here, which talks about this entire facts that I've already shared with you. Niranjan Shankar, certain foreign companies agreed to transfer their technical know-how to the respondent company. Okay, technical know-how, again, something very specific to them, to be used exclusively by this particular company. See, right? Exclusively. That is what we have to understand. Now, Niranjan was appointed as a shift supervisor, and here he quits after the training, he quits the place. So, if you see the pink highlighted portion, this entire thing was done because the information knowledge disclosed to him during this period was different from that of the general knowledge and experience that he might have gained while in the service of this company. And disclosing the same to the rival company required protection, and that is how the judgment was given in favor of C, and the injunction order was passed. Why was this so done? The pink paragraph speaks loudly. It says the knowledge disclosed to him during the period of training was different from the general knowledge. As I told you, the facts are deciding why here injunction has been allowed. So this is during employment. During employment, certain set of restrictions can be imposed on you, which will be qualified and which will be considered as valid in the eyes of law. But what about post-employment? The biggest issue arises after post-employment, right? You have left a job, you have left it for some good or bad reason, and now you move to a new setup, and you are not allowed to do that. How will you feel? Will you not feel that Article 19 is going in vain? Will you not feel that your entire concept of fundamental rights is going in drain? So that is why we have this next case law. Okay, let's try to understand the next case law over here. This is Superintendent's Company of India Private Limited versus Krishan Murgai. What happened in this case? As the name sounds, Superintendent's Company of India. So this was a company which was dealing with security services. Okay, and they had an employee, Krishan Murgai. Now, Krishan Murgai left the job, and he did not leave it. His job was terminated. So I'll just draw it here. He was terminated from his job. Now, when he was terminated, what happened is that Krishan Murgai said, okay, I will leave. And he established his own company. Okay. And what was this company about? This was again about surveillance. And not just that, so the same nature of business, okay, as that of the old employer. Secondly, did he start it in the same area? Yes, he did. So he started the services to be given in the same area of Delhi. Now let's try to understand what will happen here. He is no more an employee of this company. He has not left the company. His employment was terminated by this company. And now when he goes home and decides that I will run my own business, I know how to do this job, this company comes and sues and says, "Oh, even though the contract of employment has ended, you still cannot do that." Now, how did this company actually reach to the court? Because of this clause. Okay, so we have to understand and read the clause of the agreement entered into between these two parties, that you will not be permitted to join any firm of our competitors or run a business of your own in similar lines, directly or indirectly, for a period of 2 years and a place of your last posting after you leave the company. Okay, I've highlighted for your convenience the entire yellow and pink part is the important part that we are reading. This is clause 10 from the agreement entered into between the two parties, by which they say that there is a restriction of time period, there is a restriction with respect to the geographical area as well as the usage of the term leave. So if you see here, they have referred to the term leave the company. Did he leave the company? Now, if your client comes to you with same set of facts, how will you help him? Will you tell him that, okay, this was termination and this is not leaving? Or will you say, okay, you were not supposed to actually open this new business? So let's try to understand. The court here held that leaving is a bigger term, is a wider term, which will include termination also. Secondly, the court said that this period of 2 years and place of last posting looks like a reasonable ground. So please understand, when we are discussing about the post employment scenario, there are multiple clauses of this sort which occur and which actually exist in agreements. They get qualified or they get a validity when they are reasonable. Okay, what did I say? That this set of a clause or this type of a clause in an agreement will get validity when it is reasonable. Now, this 2 year period is reasonable or not, we will have to see the nature of business. As I told you, you have to see when the fact comes in front of you, you have to see what am I selling, what is my client selling, and whether this is similar to the precedent that we have in this particular case of 1980, and then accordingly come to a conclusion. Okay, so here the court realized and said that this entire period of 2 years looks like a very fine period, a reasonable period, and accordingly it should be considered as valid. Okay, then if you see, this was a case from 1980. The next case present just after that is of 2024. So I go back to my chronology and I remind you that we have started reading this topic from 1872 and we have come to a judgment that has been recently passed in 2024 and just a few months back. Okay, so in this particular case of Indus Power Tech versus HJ Industries, again there was a clause in the agreement that has been challenged. Let's try to read the clause, then I will come back to this substantial portion that we have mentioned here. So let's go to that judgment now. You see, when you read the judgment, you will find that how the judges have come to a conclusion. You have to read the facts, understand what all precedents have been used, because you can be the lawyer from either of the sides. If you are writing your judiciary examination, you have to understand the entire section 27, when you're making your notes, you have to prepare a chronology of, I will first explain what is business trade profession. I will then explain how section 27 was codified. And then I will come to the exceptions, right? Then I will go on and decide what are the different categorization of restraint. So as a judiciary aspirant, as a lawyer, you have to calculatively read the judgment, read the bare text from the bare act as well as books. So what has happened in this particular case is, let's try to read the essential element. Okay, we have clause 3 actually. So I'll just so this is clause 3 of this particular uh, agreement that existed between the two parties. We'll try to read the clause 3 and then we will come and understand whether post employment this clause 3 will be applicable or not. What is the title of clause 3? It is non-compete, non-solicitation. We will read this just after, 2-3 more slides. We will come and understand non-compete and non-solicitation. But just for your understanding right now, you can put a clause in your agreement by which you tell the person, your employee, listen, you can't compete with me. This is what happened in the previous case, right? That you cannot compete. You can't have your own business and then compete with us. Secondly, non-solicitation. So how do you solicit? Let's say I am working with Livelaw right now. Okay, this is an example that you can immediately relate to. Or you are working with your employer, you will have access to certain databases. Now I have access to the students list that I can see right now. If you are a lawyer, you're practicing with a senior, you will have access to his client list maybe. So in that set of a situation, non-solicitation clause comes into picture to protect the right of the employer. The employer can put a clause of this sort. We will take your question at the end. Okay, the employer can put a clause of this sort in the agreement and say that you will not use my consumer list, my customer list, my students list, my clients list, even after the employment ends. Okay, you cannot use that, and that is non-solicitation. So the supplier in this case agrees that the company shall have exclusive right to deal with all the customers or clients introduced to it by the company from within the geographical boundaries. And during the term of this agreement, okay, so pehli cheez kya hai? The first important aspect is that the supplier agrees. One person is the supplier, this party is the supplier. Okay, HJ Industries, they were the suppliers, and this is the company that we are talking about. So the supplier agrees that a company shall have exclusive right to deal with all the customers. Sir, you have all the right to deal with my customers or clients introduced to it by the company. But during the term of this agreement and for a period of 24 months after the termination of this agreement. So there is a clause that is mentioned which says, for how long are you bound by this non-compete and non-solicitation clause? That is for the during the subsistence of the agreement, that is the period when the agreement is in force, plus 24 months after it is terminated. So the court in this case said that we have to refer and we have to understand that non-compete clause can operate validly only and only during the term of the agreement. In most of the cases, you will find that they will be valid during the term of the agreement, but it would not be valid post termination. Of course, exceptions exist. When I speak of trade secrets, it can get extended also, right? But that is because of special laws coming into rescue. So we have multiple laws here, which is Competition Act, IP Act, then various IP laws. Then we speak about Partnership Act. So there are multiple laws that are related or that are branching out of Section 27. But for us to understand right now Section 27 in context of this judgment, we realize that the court has taken a restrictive view for post-employment scenario. Once your employment ends, you cannot put a blanket restriction on the employee and say that, okay, you cannot do this, you cannot do that. That will not be applicable. again, subjective to the facts of the case. There are multiple cases, wherein you will find that the court allows, if it doesn't look like you have actually accessed the customer list or the consumer list or their databases, and it's a very general information that you have, in that sort of a situation, you cannot actually put a non-solicitation clause as a ground of defense. Okay. Now moving to what is reasonable. I have consumed 47 minutes of one-sided interaction. I am waiting very impatiently to take your doubts. Just hold your doubts for a few more minutes. We'll complete this and then we will have a discussion. Okay. So let's just understand the next topic now related to this, that what is reasonable. So I'll tell you why this question has come into picture. Now, what have we read so far? We have read categorization of restraint. We have read one category was absolute and partial. We read the next category was during the employment and post employment. Now, the judiciary is, if you see all these judgments, the judiciary is actually coming to rescue in all these cases. Wherever it is finding that there is a loophole, there is a lacuna, I have to come and I have to help my people. So, likewise, the judiciary has tried to define this reasonable. What reasonable? What is the context, ma'am? So, actually, the UK law, if you remember in the beginning of the class, I spoke about the law that exists in the common law countries versus the law that we have, section 27. We did not follow the Law Commission of India report, which stated and which told us that we need to have an exception of a restraint being allowed when it is reasonable. Okay, what is it? That if there is a restraint, if there is a clause that restrains you from professing any business or trade, in that particular situation, the restraint will be allowed provided the restraint is reasonable. Now, what is reasonable? So, reasonable is something that will depend on the nature of the job that you're doing. Okay, whether you are an IT professional, whether you're a lawyer, whether you are somebody like the previous case that we discussed about Niranjan Shankar, who was a supervisor and who had access to the trade secrets. It will depend on the geographical facet, that what is the restraint that has been put. Is it only for a locality like what happened in Madhuchandar, or is it for you to not practice it in anywhere in the country, right? So we also have to see the geographical ambit of the same. Now, just to understand reasonable better, we will read it in the context of this judgment. Association of Medical Super Specialty Aspirants, just like most of us, and Resident and Others versus Union of India. So what happened in this case is that there were students who have qualified their medical examination, and now when they have to join their medical colleges, there was a restriction or there was a clause present in their joining. Before you join, you have to give a compulsory bond. Compulsory bond for a student, what it could be? The compulsory bond was that once you graduate, you have to provide services for a certain period of time, 12 months, 18 months, in some rural undeserved area. Okay, so the agreement, when you have qualified your exam on merit, okay, then when you are going to take your admission, at that stage only a bond is put to you that your admission will get final only and only when you sign this compulsory bond, that you will go and serve in this particular area that is underserved. Matlab, it has to be something which is, which is in the village area, rural area. To challenge this, the Association of Medical Super Specialty reaches to the court. Now, this is a very good judgment which you can read in light of fundamental rights of people. But here, because we are restricting our discussion to section 27, the court held that, see, when you are reaching to a medical college, which is a government medical college, it is subsidized education. So we have anyway given you subsidized education. Then the second is that the legislative intent in making a law of this sort is what? to serve those people. The state is not doing this to harm you, the aspirant who is qualified and will be a doctor after he starts actually serving. This is actually done following the utilitarian principle, which talks about maximum benefit for maximum number of people. So it is going to benefit you because you are getting a subsidized education by the state. You will also get a remuneration and an immediate job after you graduate, as well as it will benefit the society at large when you actually provide aid in the underserved areas. But this is all with respect to the facts of the case. Here, considering whether the bond was fine or not, whether the bond is falling under the category of section 27 and is restraining trade or not, the court said no, it is not actually so, only and only because the terms of the bond are reasonable. How can the terms of the bond be considered reasonable? Let's refer to the judgment. Because the bond was for a very limited period of time. Secondly, because they were also getting paid by the court in the same situation. Okay. So I'll just go to the last part. It's a lengthy judgment. So the court here said that the compulsory bond operates only and only during the period of employment. Taking us back to this entire thing. During employment, did we allow certain restrictions? Yes. So the bond was only and only during the period of employment, first thing. Secondly, the appellants to serve the government for a few years under a reasonable terms cannot be described as one in the restraint of trade. So as long as the terms are reasonable, if it is, if it is benefiting you and the society at large, the court will accordingly take their view. So this is the fifth case law that we have discussed so far to understand what is reasonable. Now we're coming to the exceptions finally. So the exceptions is the most beautiful part. Why so? Because after you read the exception, you understand that we have tried to balance the right of the employer and employee. Okay. And how is that? So the first statutory exception that we have, as mentioned under section 27, is talking about sale of goodwill. Coming to my previous example, I don't know you have written yes or no to the example, but I discussed about one of the cases, right? This case of famous samosa wala selling his business to the infamous samosa wala for some amount of money. Now let me add to this. When he sold his business or his goodwill to B, okay, B has now put a clause in the contract. B says, A, you're selling me your business. Good. Thank you. But at the same time, please promise me that you will not open, okay? You will not open another shop in the same locality maybe. Or you will not start making samosas in next 20 years or in next 5 years. If such a clause is put in a contract where goodwill has been sold to B, will this be qualified and will this be a valid contract or not? Okay. So this is the example that we have discussed. And in context of that, we have our first exception of sale of goodwill. What is goodwill? I told you what Lord Eldon had said. Now, McNaughton has said here, goodwill is the benefit and advantage of the good name, reputation, and connection of a business. As I told you, if you like Domino's, if you like Haldirams, if you like Diggin, whatever you may like, is the benefit and advantage of the good name. You like that particular place for a particular reason. You have a reputation in your mind with respect to that particular business. It is the attractive force which bring in customers. So when A, the famous samosa wala, had a lot of customers, they were going to him. Now, when this is sold, this goodwill is sold to B and B starts selling the samosas under A's name. It is the sale of goodwill. And such sale of goodwill in a contract or in an agreement of a sale of goodwill, you can actually be allowed to put a clause restricting the other party to restraint from trade. So that is what has been qualified as the first exception under section 27 of the Indian Contract Act. You can read this case law also. This is very similar to the facts that I have discussed in the example of A and B. Again, the restraint on goodwill also has reasonable. Please know that it is not an absolute restriction that you have received. Okay, you can't take the benefit and say, okay, I will restrict you forever. No, if you read the provision now, let's read exception 1 from the bare text. What does it say? It says one who sells the goodwill of a business may agree with the buyer. The seller may agree. A, the famous samosa wala, may agree with the buyer to refrain from carrying on a similar business. Carrying on what? A similar business. Can A go and start, a job in the car shop? Yes, he can do so. Within specified local limits, the legislature has helped us. They have themselves given the threshold of reasonable to us. Similar business, specified local limits, so long as the buyer or any person deriving his title, that such limit appears to the court to be reasonable, regard being had to the nature of business. So we have to make sure that the court, when they are deciding that yes, goodwill was sold, they have to also see the reasonableness of the restriction imposed on such goodwill. You cannot simply tell the person that perpetually you cannot sell samosas anywhere in the country or anywhere in the world. So reasonableness of this restraint also has to be there. Now we are moving to the exceptions as identified by judiciary. Okay. This is very important and essential. We have certain exceptions that are there in the other laws that we will discuss just after this. But these two exceptions identified by the judiciary has been, you can trace them in a lot of cases. Okay. And these are very important. The first one, as we discussed, is non-solicitation of customers and employees. You have to make sure that you do not solicit the customers and employees. See, you have access to the databases. You have, so what happened in MB Software Private Limited only? Sameer Kumar Shaw was the employee of MB Software Private Limited. When you read the judgment, you will find that Sameer was not an IT professional. He was a BCom qualified employee who was actually handling the data of all the people who were buying the software from the company. Sameer and 4 more people decide to leave this company, and they decide on their own to establish a new business similar to the business run by MB Software Private Limited. Now, MB immediately runs to the court, restraining them and telling the court that this is a similar business and they should not be allowed to run the same. I hope I'm clear with the facts. MB is the employer. Okay. Sameer Shah was the employee. The employee leaves the job with 4 more people. He starts his new company, similar trade, similar business. Okay. Very important fact is, because on this ground, this plaintiff was challenging Sameer's access to the data. He says that he was not an IT professional. He was somebody who was actually working as the data operator, and he had access to all our data. The court got into the depth of the case, and the court saw that what Sameer was buying, the softwares that they were buying, was very general and they were actually famous. Now, if I say that Apple is being used by Livelaw and everybody should, everybody else starts buying Apple, so will that be related? Maybe Apple is famous, maybe Samsung is famous. So you have to accordingly see the facts and decide. Sameer was using the software that were very famous, and that is how it cannot be said that he has stolen your data or he has actually taken the details from your software system. Okay. So we go back to this case and we find a non-solicitation clause in an employment contract does not amount to restraint. If I put a clause in my contract and I say you will not solicit, you will not take away my information even after the employment ends, it will still be considered as a valid clause. I am not restraining you from any sort of running of business. Now, if you see in the pink, I have highlighted tortious act and tortious liability. Please drop your comment in the chat box that what could be the tort that is happening here. I'll give you a hint. Okay. Sameer has access to his software. X is the company. Y is Sameer. Okay. Sameer has access to the software who was selling to software companies who was selling to MB. Sameer calls these software companies and tells them, you don't have to go to MB. I will give you a better price. Please come to me. Is this is a tort? If yes, which tort will it be? What has Sameer done? He has induced this person, all these parties, the client of MB Software Private Limited, to leave the contract that they have with them and to join and have a contract with Sameer. So if you're listening to me, please, and if you know the answer, give it a try. Write your answer in the chat box as to what tort is happening here. Okay. So these are exceptions as identified by judiciary. The first one was related to non-solicitation. The second is non-disclosure of confidential information or trade secrets. So we have discussed this, that all the trade secrets or the confidential information that is with you, even after the employment, you cannot share it. Okay. And the clause that is so there will not be challenged. The third and very interesting one is restricting franchisees from dealing with competitive product. Now, what is a franchise agreement? There is a franchisor. I'll give you an example from my home itself. Okay. I have an aunt who has a salon, and in that salon, she has a franchisee. She's taken the franchisee from Shehnaz Hussain. Okay. Now, in her salon, she only and only uses the products of Shehnaz. So when I was young, I asked her one day that, do you have a contract with her? Why don't you try new products on your clients? So from that, we understood that she had a term in her contract by which the franchisor, that is Shehnaz Hussain, can restrict her from dealing with other competitive products. How is this beneficial for the franchisor? Because this is securing their position, right? The entire concept of a franchise agreement is promoting such sort of a trade where the franchisee is trusting each other, and that is how the franchisee is taking further the products of the franchisor. So such grounds can be there, such clauses can be there in the franchisee agreement. Very famous case, you will find this also getting quoted in a lot of judgment, that is the Gujarat Bottling Company versus Coca-Cola Company. I'll just briefly tell you, the GBC, called as Gujarat Bottling Company, was in a contract with Coca-Cola Company that they will only make the containers for them till the contract is in existence. Okay. Now, I have taken the important paragraph here from the agreement. The agreement between the two parties had this paragraph. What does it say? As such, the bottler covenants that the bottler will not manufacture bottles, sell, deal, or otherwise be concerned with the products, beverages of any other brand or trademarks, trade names during the subsistence of this agreement, including the period of 1 year's notice as contemplated in para 21. So we have told GBC, Coca-Cola tells GBC, listen, till the time we are in contract, our contract is subsisting, you cannot manufacture your bottles, deal with these bottles with any other competitive company. In addition to this, not just during the subsistence of the contract, also you have to wait for 1 year from the period of termination of contract. So do you think this is fine? This was considered to be a valid covenant or a valid ground or a restriction put on the person to protect the interest of the both the parties, that is the franchisor and the franchisee. Okay. So the restrictive covenants in the franchise agreements can be valid and enforceable if they are, again, reasonable and they're necessary to protect legitimate interest of the franchisor. Okay. Then we have various other exceptions that are recognized under law. As I told you, we have Indian Partnership Act. Okay. So Indian Partnership Act, which talks about or which lays down the principle of how a partnership works, different partners coming together and making the partnership work. There are sections like 11, 36, 54, which lays down, if you read these provisions, you will find a lot of similarity. Okay, so if you really like and if you have understood the lecture, you can leave a feedback also in the comment box whether you want an entire discussion to be done on this, or you can join our course and read this with me in our class. So this is Partnership Act, wherein we say that while you are a subsisting partner, after you quit the partnership, when you are in anticipation of quitting the partnership, in all three cases, there can be reasonable restrictions that can be imposed on the partner to not, do the same competing business as that of the partnership. Then Competition Act also, if you read this provision, I have changed the language, but the summary here says that it prohibits, Section 3 from the Competition Act prohibits any agreement between the enterprise, persons that causes or is likely to cause an appreciable adverse effect on competition. If I restrain everybody from selling their products, or from selling or giving their services to people, will it not cause an adverse effect? Will it not be adverse for the public at large as well as those people in the trade? It will be. And likewise, this can be related and has a nexus with Section 27 of the Indian Contract Act. And solus agreements, also called as exclusive agreements, we allow and we acknowledge that there can be agreements which can be for exclusivity, that you will only sell my products, you will only advertise by my products. This exception also, this clause also, if so present in your contract, will fall or will categorize as an exception under Section 27 of the Indian Contract Act. So with this, I have now covered Section 27, the provision of Section 27, the law that is so mentioned there, the exceptions given under Section 27, as well as by way of different judgments, as well as we have also referred to the meaning of different terms like restraint, what do judges do when they get stuck in a situation of interpretation, as well as we also referred very briefly though to the idea of right of trade or right of business being part of a fundamental right under Indian Constitution. So when you're writing your answer, you will get a lot of questions similar to these landmark facts. You can write your answer in the same structure in which I have tried to explain this to you. And when you're finishing your answer, let's say two, you can expect two set of questions, right? One can be on the basis of a case law. So you'll be given facts and then you accordingly decide what should happen here. The other can be with respect to any of the statement. One statement or one clause is given and then you are expected to answer and define and explain it as to whether the clause should be considered as valid or not. So you can end your answer in that case with the suggestions that I have mentioned here. So I highlighted a lot of times about the changes that have not been done in the Indian Contract Act. So you can mention that. You can expect this sort of a question in your interview also. You can also always talk about equal protection that is to be given to the employer and employee. So both the parties in the present context of developed society where a lot of competitive practices are happening, lot of issues related to IP, trademark, all of this can happen. It is important that we equally protect both the parties in sort of a situation. And the last and the most important one, never forget that even after the juror relationship exists, there is a very minute exceptional ground wherein we say that you can still restrict the parties to only a few set of situations. Okay, so that can be our last discussion. I'll just end with one of the excerpts from the judgment. The judgment is mentioned here. It says, somewhere there must be a line between those contracts which are in restraint of trade and whose reasonableness can be considered by the court, and those contracts which merely regulate the normal commercial relationships between the parties and therefore are free from the doctrine. So you have to find out whether I have the scope of reaching to the court and the discussion of interpretation of reasonableness can happen here? Or is it actually that I am restricting a party from following or pursuing their trade, business, or practice? Okay, so with this, I end my lecture and I open the floor for all of you to discuss and to ask questions.
Hi everyone, you can put your questions in the chat box, or there's also a Q&A section where you can mention your questions. In the meantime, I'm sharing a message with everyone in the comment section of this webinar, which includes a feedback form link. Please take out 2 minutes to fill the feedback form. There's also a link to our Judicial Services Examination course program, and all the details are there. Please log on to the website, check out the details. There's also a contact number and an email address. In case you have any other queries, you can definitely call us or contact us there. Please ask your questions. If you have any queries, any doubts.
Okay, I can see one in the Q&A box.
We'll inform you the faculties for the respective subjects. Ma'am, there's a question by a student which says, in samosa shop exam.
Kritika, I can't hear you. Okay, I have read the question, so I'll take it further. It says that, ma'am, in the samosa shop example, will it be damnum sine injuria? Okay, I am glad that you know about this concept. Just for other people who are attending, damnum sine injuria or damnum sine injuria, as we say, wherein we talk about there is damage that has happened without injury. Now, what is injury? Violation of legal right, correct? So when I have sold my goodwill to the other person, can we really say that there is violation of legal right? No. So this is happening by way of a contract. But if you relate this to Gloucester Grammar School, then you can actually think and say that, okay, if somebody is making a competing business right in front of me, or even though not in front of me, but is actually trying to take away my clients, then it can categorize into damnum sine injuria. But not in a situation where you are voluntarily entering into a contract and accepting the terms of the contract.
I think we'll delve more into the intersection of contract and torts in our detailed classes. I think that'll make things more clear. Any other questions? We'll just wait for another few seconds if someone's typing their questions.
A lot of people were raising their hand during the lecture. You can ask your questions now, please.
Please do take out time to fill out the feedback form. I think, Akansha ma'am, your lecture was amazing. And thank you all for joining us today. And hope to see you soon with another webinar, another topic. Thank you, everyone. Thank you, ma'am. Have a great night.
Thank you, Kritika. Thank you, all of you. Thank you so much.
Hi, good evening, everyone. Akansha ma'am, we can begin.
Thank you. Thank you, Kritika. Good evening, all of you. I'll just share my screen and begin.